It's Adelola your divorce lawyer, here to help you turn fear into power when happily ever after fades away. So today we got a telephone call from a person who wanted to establish paternity of a 17-year-old child. And the person was living with a spouse who the child believed to be the child's biological parent. Okay. The case law of the state and the statute with respect to the state of New York says that you can file to establish paternity of a child up until that child turns age 21. And of course that makes sense because it goes hand in hand with the emancipation age set forth in the state of New York. Now, the case that the person was calling about was with respect to the state of New York, so I'm going to talk about New York, and I might make another video about New Jersey as well. But the concepts are the same in both states. You need to realize that the longer you wait to establish paternity of a child, the more likely it is that the court is going to say, no, we are not going to allow you to disrupt what the child knows to be the child's parent. Okay, so if you have been holding yourself out as the father of a child for 17 years and the child thinks that you are the child's father, or the child has thought that you are the child's father or were the child's father for a long period of time, and that child has established a parental relationship with you, it is highly unlikely for a court to interrupt that, even if the court knows that the DNA test is going to turn out being that you are not the child's father. The reason for that is several-fold, okay? In other words, there are several reasons for that. One of them is that the court wants to make sure that that child has a reliable source of income or support, okay? And if you have been the child's source of income or support for that many years, the court is not going to disrupt that to try to find another person who may or may not exist now to support the child, okay? The other one is that the court wants to have consistency with whom the child believes to be his or her father. All right, so the court will say, well, it's not in the best interest to interrupt the parental relationship that the child already has with the person that the child believes to be the child's father. So certainly, with respect to a child who's that old, it's gonna be highly unlikely that the court is going to enter a DNA test. Now, I'm not saying it's impossible. I'm just saying that it's unlikely. The facts and circumstances of your case may be different and may require a different approach. If you need help with something like this, establishment of paternity, figuring out whether you should even go forward, whether the court will allow you to do a DNA test, whether the court will recognize the DNA testing that you've already done, schedule a legal strategy appointment with me. I'd be more than happy to sit down with you and go over your case specifics. Because remember, as I have said in other videos, no one case is the same as any other case. Thank you so much for watching. Adelola your divorce lawyer, here to help you turn fear into power when happily ever after fades away. Click like and share along.